Okay, Justice Torres.
We're live.
We may begin. Trina.
The Supreme Court is now in session. The Honorable F. Philip Carbolito, Chief Justice, presiding.
Thank you. Good morning, councils. This court is now in session, and I will ask the clerk to please call the case.
This is Supreme Court case number CVA 19-013. David Waathdad et al., plaintiffs appellants versus Cyfred Limited, defendant appellee. Appearing for the plaintiff appellants is attorney Wason W.S. Wong. Appearing for the defendant appellee is attorney Curtis C. Vandeveld. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorney Wong reserves 10 minutes.
Thank you, Madam Clerk. Attorney Wong, you are recognized. Please begin.
Thank you. Chief Justice, may it please the court. I'd like to focus initially on what I consider our claim being a permissive counterclaim. It's the easiest, most logical, and probably fairest way to handle and dispose of this appeal. In terms of what happened in the trial court, we pled for the relief of staying non-judicial foreclosure proceedings against my clients, the homeowners at the Gilbaza subdivision, because of notes and mortgages that were given by them to Cyfred for the resolution of a settlement after more than 10 years of litigation. And what happened in this particular case in the background was that despite the settlement, there were still major flaws that needed to be resolved, more particularly title to 14 of the lots that were conveyed to my clients as part of the settlement. What we did was we intentionally decided to stop paying on the notes and mortgages after paying them diligently from 2012, when the settlement started, to 2016. We did that because we did not want to go through the nightmare of trying to collect against Cyfred as we had done in the previous cases that were settled. In those cases, we were given a judgment of over $700,000 by the trial judge, Anita Sokola. And through all kinds of machinations, we were prevented from collecting on that judgment. Those machinations included transfers in fraud of creditors, which we documented and set forth to the trial court. Transfers to attorneys for Cyfred to let us try and get our money from them instead. 2 bankruptcies, and 4 or 5 times motions against trial judges to preclude them from issuing writs of execution, motions to test their, quote, conflict of interest in the case. And I'll get to why that's all important a little bit more. But what we did in this particular case is to set off what Cyfred owed to us in our efforts to clear the title to the 14 lots against what we owed to Cyfred under the mortgage and the notes. If Cyfred had moved in judicial foreclosure to foreclose against my clients because of non-payment of the notes, we would have raised as a counterclaim and/or affirmative defense the set-off claims that we were trying to assert in this case. They are, in essence, counterclaims for the amounts of attorney's fees and damages we incurred in CV19-013-18, the case in which we were trying to clear the title to the lots as Cyfred had promised to give us.
But Mr. Wong, how does that hypothetical help you? I mean, Cyfred was not obligated to bring a judicial foreclosure. The mortgage agreement allowed it to proceed as a non-judicial foreclosure. So how is wishing that Cyfred had brought a judicial foreclosure when in fact it did not help you in your argument that Guam Rule of Civil Procedure 13 easily resolves this case?
Well, what I was saying is that I would ask the court to look beyond the formalities of the pleadings and look what was really trying to be accomplished with this set-off. In the world of fairness and common sense, what Cyfred had was a claim for money due and owing on their notes and mortgages. And what we had was a defense of set-off against that, either that by way of an affirmative defense or counterclaim. Despite the way the pleadings came forth, what I'm asking the court to do is say logically and in fairness, this really was a counterclaim. And in our jurisdiction, because we adopted FRCP Rule 13B and have in force GRCP Rule 13B, this was a permissive counterclaim that the court should have allowed as a set-off against Cyfred's claims. If it had done that, there wouldn't be any summary judgment because none of the validity aspects of our set-off was ever presented to the court for summary judgment. The only presentation to the court below for summary judgment was that you cannot set off an unliquidated claim against a liquidated claim.
But even if we were to recognize that even with the posture of it being an original claim that you're asserting in reference to the set-off amount, as was pointed out by Mr. Vanderbilt, I mean, your claims were unliquidated, contingent, and lacked mutuality. And so even under the Warren case, where you may have a unliquidated claim, you may still pursue a set-off against a liquidated claim. You still have the issue of that it was a contingent set-off claim, and it lacked mutuality, and so those conditions were not overcome by the Warren case.
Those conditions were not overcome by the Warren case. I agree with you, Mr. Chief Justice. But if you look to the North Chicago Rolling Mill Company versus St. Louis Ore and Steel Company, 152 U.S. 596, 615, an 1894 case, you'll see that the United States Supreme Court recognized the equitable exceptions to the old rule, which basically says you cannot set off an unliquidated claim against a liquidated claim, and said there are equitable exceptions to this out of fairness, especially in the situation where you have a situation where the claimant can collect on their claims.
Yeah, but that case, Mr. Wong, the North Chicago Rolling recognizes the insolvency of a party, that it can be used as an insolvency of the opposing party can be utilized to provide that a non-liquidated damages claim can still be set off against a liquidated, but it didn't say anything about the Guam rule, the rule of Civil Procedure 13B.
I agree. Okay, but let me finish my thought on North Chicago. It also talked about, through footnotes, whether the claim was mutual or non-mutual. and contingent or non-contingent, as opposed to liquidated or unliquidated. And in all three instances, if you read the case carefully, they looked and used the equitable exception to supersede all those differences. But going back to Rule 13, to address your point directly, Rule 13 was promulgated by the federal courts as part of a 1939 change in the civil rules. The old rules concerning set off against liquidated versus non-liquidated claims were there. But in my opinion, and based on the case law I've read, the United States courts changed those particular rules to allow for set-offs for any type of non-compulsory claims that a party wanted to assert, including ones that were unliquidated or non-mutual or even contingent. What the courts have indicated they wanted to do was create a situation where all cases in the interest of fairness and justice and judicial economy were handling all claims of all the parties, notwithstanding the previous old equitable limitations or the old limitations that have been placed on them by the common law. And as we go through from 1939 till now, our federal courts, and including the Lund Court in Washington and other cases around the United States, have recognized that Rule 13b is a very encompassing, broad exception or allowance of any type of non-compulsory claim against another claim, whether that other claim be liquidated and the claim being asserted as a permissive counterclaim be unliquidated. The trial court erroneously construed 13b.
Before you move on, I mean, when you look at the plain language of 13b, it provides that a pleading can state as a counterclaim any claim against an opposing party that's not arising out of the transaction or occurrence that is the subject matter of the opposing party's claim. And you know, obviously I recognize that if this was a judicial foreclosure, and as you pointed out, then the possibility to raise as a 13b permissive counterclaim the fees that were incurred to clear the title could have been raised. But in this situation, as was requested, that's not the posture of the case that came before us. And I have not seen a situation where the and admittedly, and I think you admit that it's a contingent, unliquidated, non-mutual claim, is brought as an original action, not as a permissive counterclaim under 13b. So this process, I mean, the holding in Warren and the manner in which that case came out doesn't seem to be applied in this situation, at least in the procedural posture of this case. And so at least looking at 13b, I have a difficult time understanding how, with the posture of this case, that would be a permissive counterclaim that would be allowed when it was brought as an original action, not as a permissive counterclaim, number one. And then, and so that's my first concern, and I want to hear what you have thoughts on that. And then I want to go back to your issue on the North Chicago, because you reference that North Chicago stands for the proposition that non-mutual claims would still be able to be offset. And I don't read it that way. And I reread that case this morning. So I'm hoping you can direct me to that. But answer that first question first, please.
Sure. I can't really say to you, first of all, we're not raising an affirmative claim for dollars in terms of CV0735-18. What the set-off was alleged to provide was a set-off to preclude non-judicial foreclosures. The remedy we sought was not dollars necessarily in CV0735-18. It was to go ahead and obtain a preliminary injunction against the non-judicial foreclosures. We still had our claims for the attorney's fees in CV19-013. That's number one. And number two, the only thing that I'm really arguing to the justices of this court is please accept substance over form. And with that, I'll leave Rule 13B and focus on the exceptions. If this court wants to go back in time and apply in Guam the old common law rules, then it may. But the exceptions exist. For instance, insolvency. We mentioned North Chicago. If the court will take a look at that footnote that I put in forward concerning the Illinois Supreme Court, that the Supreme Court of the United States cited to with approval in my first amended opening brief, you'll see that the Supreme Court of Illinois case involved a non-mutual contingent claim. What the offset was argued for was in arbitration, one of the parties to the arbitration had been bonded by the party claiming the money in the first case. And because that party lost in the arbitration, the party to which the first party was claiming money against used the bonding opportunity or obligation to try and offset the money claimed by the party seeking the judgment and payment in the first case. And the Supreme Court of Illinois said, that's okay if there was insolvency in terms of the party in which the claim for money was being brought. So when I read that, Justice Torres, I see that not only unliquidated, non-mutual, and contingent claims were allowed to be asserted against a liquidated claim by the Supreme Court of the United States in terms of allowing the fairness aspect of insolvency to take over, such that equity provided for relief when,
But if you look at the holding of North Chicago, it just references cross demands and counterclaims arising out of the same or wholly disconnected transactions, and whether liquidated or non-liquidated may be enforced by set-off. It doesn't reference contingent claims. It doesn't reference non-mutual claims. I read that when you said, wholly disconnected transactions, as suggesting that meant that even if the parties were, there was not mutuality of parties, that you could offset those claims. And I don't read it the same way.
I appreciate that. Okay, I read that particular case that way, as allowing for that, because the basic idea of this exception to the old rule was to go ahead and give the opportunity of the party trying to seek to set off an opportunity to collect rather than collect empty-handedly. And that purpose or principle applies whether the claim is unliquidated, non-mutual, or contingent. The whole aspect of the equitable relief allowed for by North Chicago and most of the jurisdictions of the United States that allow these exceptions is to go ahead and prevent the inequity of what can happen and what probably will happen in this case. Cyfred will collect on its notes and mortgages, and the homeowners will be left sucking wind again at the end of their case. It's just not fair, and that's what equity is designed to go ahead and address. And that exception clearly applies in this case. We showed by the facts that we presented that Cyfred is insolvent. The trial judge used the wrong insolvency premise to go ahead and determine that Cyfred was solvent.
Well, I thought the trial court on the issue of insolvency looked at the definition under Guam law, the ability to pay debts in the ordinary course, or whether they were insolvent within the meaning of federal bankruptcy law.
She did, but she
Okay.
only looked at the first part and didn't check federal bankruptcy law. Under our UCC, federal bankruptcy law that was referenced indicates that a party is insolvent when its liabilities exceed its assets. And we showed by facts, or either the facts viewed in the light most favorable to the homeowners, that Cyfred owed at least $281,000.
What were those, where in the record were those factual citations to the amount of, and not just broad allegations in terms of the amounts that were owed and the assets that they had?
Yeah, I took the deposition of Mr. Gill. It was late because he never appeared in the case, in other cases until 2019. But when I found out that the only assets that Cyfred owned were these notes and mortgages. And I knew already by a summary judgment that I obtained in CV0425-18 that Cyfred owed me $81,000 plus on the promissory note it gave me as part of the settlement, plus interest and attorney's fees, which were never calculated. Okay. That's a debt. I also,
that's 81,000, but I mean, you're saying that the value of the property here was about 168,000, and then you make this allegation that the debts were 281,000.
yes, that was made on a probable basis. But again, I asked the court to look at the facts in light of the way most favorable in terms of my
Well,
client.
where are those facts to show the amount of the debt and satisfy the insolvency? I mean, because that the trial court in its decision, suggested that there were no facts to support the insolvency.
Yeah.
I mean,
The $81,000 was fully supported. The other fact that I used was that I had incurred in CV0426-18 at least $200,000 in attorney's fees. And I represented to the court that I would indicate that probably Cyfred had incurred the same with Mr. Vandeveld in his astute and diligent representation of Cyfred in that case. Okay, so when you add the 200,000 to the 81, that exceeded the 168 that was determined by Cyfred in its notice of non-judicial foreclosures when it started to pigeonhole the amount of the value of each lot. But in the record,
the arrangement. So I mean, you didn't put forth any evidence showing what the arrangement might have been between Mr. Vandeveld and Cyfred for his attorney's fees in connection with that case, and your fees. There was no determination that you might have been required. Cyfred might have been required to pay those fees. In fact, the court pointed out that in the two UPIC 1 and 2, that you weren't the prevailing party in those matters entitled to fees.
Yeah. Well, I wasn't trying to use my fees. I was trying to use Mr. Vandeveld's fees.
I understand that, but you don't have any basis, or there is no evidence that you've put forth what the relationship is between Mr. Vandeveld and Cyfred for payment of their fees in this case, right?
I did. When I took Mr. Gill's deposition, I confirmed for him that the amounts that Cyfred owed Mr. Vandeveld, his attorney's fees. But I also—
where is that in the record? Can you point that? Because that's important, I think, then, if you're able to determine where is that in the record that Mr. Gill said he owed them $200,000?
Well, he didn't say that. He said the Cyfred owes Mr. Vandeveld attorney's fees. And the only one point I want to make where I—
Yeah, but how much? I mean, the amount is important for determining the insolvency test.
I agree. In the record of this particular case, Mr. Vandeveld's fees were $96,000 plus that he requested. Just for this case, when you add the 96 plus the 81, you exceed the value of the assets already. But I will yield to Mr. Vandeveld because I've used up most of my time as far as my direct argument is concerned. Thank you.
I'm sorry, Chief Justice, I didn't hear you. You're muted.
Oh, sorry, I was muted. Yeah, I thought I unmuted myself. You may proceed. Thank you.
Thank you. If it please the court, Your Honors, First off, the initial claim for attorney's fees, as Justice Torres pointed out, that was used as an offset was for litigation that was widely improperly handled, and the court made a finding that they were not the prevailing party entitled to any attorney's fees in those actions, and that was CVA19-013 and 73-16. And then, of course, the appeal that was untimely of the decision in CV73-16 that this court dismissed. Then later on, and without any claim actually pled, Mr. Wong considers that he has a counterclaim. But if you look at the supplemental exhibits, it includes the answer to plaintiff's complaint by defendant Cyfred Limited, and it makes no claims back against him. And so you can't have a counterclaim to an action where there are no claims, and it's just completely improper according to procedure. Mr. Wong tries to always rely upon, well, if I don't do things competently, I ask you to look beyond what it is that I really did do and how I really presented the case, but just give me what I want because it's ultimately fair.
Do you agree that if this case, if you had sought judicial foreclosures, that Mr. Wong could have brought the counterclaim for the fees incurred in trying to clear title to the properties that you were the subject of foreclosure?
No, I don't agree that it would be a proper counterclaim under those circumstances. The issue really in foreclosure, well, because foreclosure actions are not, they are not equitable actions for the purpose of being able to assert whatever claim you may want to. And even in this particular case, the circumstances of what it is that they want to do isn't consistent with being able to get offset for anything that they were entitled to. It would still go back to, you'd have to look at what is the nature of the claim, and the claim, as was identified early on in the litigation, were attorney's fees in the three forms of litigation that they lost. Now, going to CV 426, summary judgment was granted to Cyfred in that case. So nowhere along the way,
aren't there still pending claims? And so he argues that that interlocutory summary judgment order is really irrelevant for purposes of the other attorney's fees that they assert are due in 426.18.
Okay, relative to what are the outstanding claims, for example, he misstates the fact in CV 425, he did not get any judgment. He has no liquidated judgment. That matter is still pending litigation, whether or not there was fraud committed by Mr. Wong, because Mr. Wong indicated that he had authority to act on behalf of people. 3 people who at the time that he represented, he had authority to act on behalf of, were deceased. He did not have fee agreements with people in 2012 to be able to enter into the relationship. He didn't get those until later. I provided that in the supplemental exhibits. He simply would not have been able to offset against the in a foreclosure action claims for CV 934-15, CV 73-16, and the ultimate appeal that was rejected because he did not prevail, and the trial court properly analyzed that and determined that there were no claims to be offset.
So what about 426.18? What about that the claims for damages and fees and costs in that case?
In that case, again, I argue there is no ability on his behalf to prevail. And the trial court found that he did not meet his burden of proof. And I think that that's an important consideration. The court said you didn't come forward with sufficient evidence, which is your burden, and clearly Mr. Wong didn't meet his burden. Relative to the issue of, so what Mr. Wong says is that—
Can you address the issue of the solvency of Cyfred and Mr. Wong's assertion that that there is sufficient evidence in the record to create a genuine issue of material fact as to the solvency of Cyfred because of the attorney's fees that they would owe you vis-a-vis the value of the properties?
Yes, Justice Torres. First of all, it's wholly speculative. There was no evidence presented. And Mr. Wong then tried to represent the issue on reconsideration. And again, the trial court said, you know, you're not bringing to the court anything that wasn't available to you beforehand. You had the opportunity to present this evidence at the time of the decision on summary judgment. It was your duty and obligation to present that evidence at time of summary judgment, and you failed to do so. And even what you're presenting now doesn't reach that standard. The financial arrangements that exist between Cyfred and its attorney are not part of the evidence in this case, and I'm not going to supplement the evidence in this case with something that's outside of the evidence before the trial court, because that would be, I believe, inappropriate. All I would say is—
You say there is no evidence in the record to support the fees that are owed you, contrary to what Mr. Wong asserts. He says
just Mr. Wong's wild speculation and nothing more, Your Honor. And the court found that was not adequate evidence. It was just simply wild speculation. And I think it's really important to understand that what Mr. Wong is saying here is, well, okay, maybe legally we're not, completely sound, but the insolvency exception, it's an equitable exception, and give us equity. But what the court should see is that in the decision in order, the trial court specifically had told Mr. Wong and his clients, if you want to continue the stay, you must post a bond. And Mr. Wong's clients repetitively said, we have no money, we're indigent. So the longer that this litigation goes on, the more that he tries to financially exhaust my client. He wants to be able to rely on that and then say, well, see, Cyfred is insolvent. It doesn't matter the fact that if a judgment ultimately is granted to Cyfred, they'll never be able to collect. It only matters whether or not we won't be able to collect. And that's not equity. In order to gain equity, you must do equity. You must be able to come to the court and say, we're solvent, we will be able to pay any judgment that comes against us. That's why it is important.
Court, it seems like this is the unclean hands argument that you raised in your brief. But the trial court never really addressed that at all in its summary judgment decision, the unclean hands argument.
I understand that, and I'm just saying, I think that this court can, if you're going to apply the law de novo, I believe that relative to the factual conclusions, that it is clear error, and I believe that as to the summary judgment, the de novo is looking at the facts as determined and applying them to the law, and that is the de novo portion of the court's review. But I would say that relative to this particular circumstance, these arguments that are now being advanced, I believe that the issue of the lack of equity to do equity is appropriate for you to consider. If you're going to consider some equitable relief, then I think it's important to understand there is no equity on the other side, Justice Torres. So at this point, what we have is we have a group of homeowners who are not the same as all of the people contractually. the people contractually under the settlement are only a portion of them are the plaintiffs in CV 735. The trial court pointed out there is no correlation between all of the people in this case and all of the other people. There's no ability to determine what rights belong to other people and can't be applied. And I think what even when you listen to Mr. Wong's argument about what he claims are amounts that are due to him in CV 425-18, he is not a plaintiff in CV 735-18. He's not a plaintiff. He became a plaintiff late in CV 426-18 because he claims that he has promissory notes where he's owed money by his clients, which if Cyfred prevails, his interest in those promissory notes will get wiped out because Cyfred will take their interest first. And so what Mr. Wong has is he's arguing that he's in conflict with his clients, but he wants to be able to say, well, but I have this separate thing that would be mine and I can apply it. But that's not correct because the offset, any set off has to belong to the people who are the litigants in the case. And in CV 735, he's not a litigant. Now he could go ahead and help his clients, I suppose, if he wanted to, but he's not a litigant. It's not a counterclaim. It's not even a permissive counterclaim. It doesn't even come close to any legal standing for him to be able to say, here's an amount of money due me, and so therefore that could be a set off. He has no legal standing to do that.
If Mr. Wong's claims related only to the parties who were actual parties to this case and did not include claims from other parties, so there's no mutuality issue, would a contingent unliquidated counterclaim be pled as a set off here?
I don't believe so. I don't think that's the holding in either the Warren, Little versus Max J. Kinney case, and I don't think that's consistent with the North Chicago Rolling Mill Company versus Oregon Steel Company case. In those cases, the transactions arose out of the same, or the unliquidated claims arose out of the same transaction. This is not the same transaction. This is a separate transaction. The transaction of the promissory notes and mortgages are completely separate from the settlement issue, and they have not been pled as a claim. So there is no. It is not the same transaction, and so whereas in those two cases the court focused on the fact that it arose from the same transaction, that's not the circumstances here.
Isn't the Warren holding a little broader though, and is it just not limited to? Because I mean, in fact, I'm looking at the holding now, and it says we hold a contingent unliquidated counterclaim may be pled as a set-off unless the plaintiff can show prejudice or the counterclaim would make the proceedings unwieldy. So it doesn't address the mutuality of the parties. So I'm asking, putting that aside, the Warren court seems to accept that even if it's a contingent claim, you at least able to raise it as a counterclaim under 13, the Rule 13.
I agree that's what the holding itself says, but when you look at the circumstances of what it was that were being addressed in that particular case, what was the circumstances in that case, it was a concern over a matter which arose from the same transaction. I
think that's the Rule 13. Is it it's not arising out of the same transaction. I mean, that's the whole purpose of 13B, is it doesn't have to arise out of the same transaction. And that's what the court was addressing there. I mean, I'm just looking at the breadth. I mean, I still think the mutuality of parties is an issue, but it seems that if we were going to be broad enough and look at the Warren, and of course the procedural posture of the case, but Warren seems to suggest that, at least held, that even if the claim is contingent, which wasn't the way I read the common law rule. The common law rule did not allow contingent claims and only allowed unliquidated claims to be offset. But Warren seemed to have a broader view of what could be permissible under the Rule 13 regime.
I understand that it says allowing the pleading of contingent unliquidated claims such as CUNY's furthers the objective to provide complete relief to parties, to conserve judicial resources, and to avoid the proliferation of lawsuits. But we don't have an avoidance of proliferation of lawsuits. We have constant proliferation of lawsuits in this particular case. The court very well could find that this is unwieldy and not determine that it's necessary to wait. And as I indicated, I don't believe that this is an appropriate counterclaim in an action where there is foreclosure. Foreclosure is a very summary proceeding. It's not intended to be the defenses to payment are that you paid it. And in this particular case, you have to go to what was the initially alleged basis to get the restraining order in the first place in CV19-013. And these were claims for attorney's fees that were based upon improper procedural actions by plaintiffs and an appeal that they lost because of it being untimely. I suppose at some point, the court has to find that these unliquidated, unspecified claims just become unwieldy as the Warren Washington Supreme Court case holds. And so I believe that at some point in the litigation, this is not going to serve for the reduction of litigation. It's going to, all it does is it frustrates my client's ability to finance litigation on its part. And that's really the tactic that the trial court found, is that this is Mr. Wong's tactic in litigation. He brings a proliferation of lawsuits to financially exhaust the opposing party so that he can then prevail because the opponent is financially exhausted. The trial court found this is his strategy. This is how he works. So he can come forth with any bogus series of claims and just keep changing the series of claims and insist that he has a reason to avoid summary judgment because, well, I'm going to come up with a theory somewhere down the line. I want to actually have a claim or some idea of a claim, an unliquidated claim, somewhere down the line that I think I might be able to get prevailing upon. And so what would happen is, if you adopt that kind of theory of litigation, almost all cases before the court can be forestalled by some bogus assertion of some claim that they're entitled to. As the trial court found, as to the claims against Cyfred, Cyfred had met its obligations in regards to the settlement. That part of the summary judgment was favorable in CV426-18 to Cyfred. Cyfred, there's the claim about fraud on Mr. Wong's clients, that also summary judgment was granted. The settlement required that my client provide the deed, which it did, that it would have Ms. Mendiola come and turn over a deed at the time of the closing of the first phase. The first phase closing occurred. Mr. Wong issued a notice as required under the agreement to claim breach, but it was for a completely different matter. And Ms. Mendiola didn't show up. Mr. Wong proceeded ahead with the closing, and the contract on its terms very clearly said, once you close, all the obligations that were due to be performed are considered performed. So the trial court said, I don't find this to be a worthy claim that would be an offset. And so I think that I believe that the trial court applied the proper standard. I would also point out, as to Mr. Wong's argument about federal bankruptcy, it doesn't have to be the entity that goes and files a petition for bankruptcy. Anybody can file a petition for bankruptcy against someone who is their debtor and claim that they are insolvent, but they have to be able to prove that they're insolvent. Hasn't been done. So the trial court applied the proper standard under Guam law, and in doing so, found that there was no evidence of insolvency because Cyfred has been able to timely pay its bills. Unless your honors have any further questions, I believe that the brief that we filed, it doesn't really matter how it's recharacterized between the supplementals and the original briefs. It really is exactly the same issues that have been presented in both instances. I believe our brief clearly points out the flaws in the arguments in both. Thank you.
All right. There are no other questions for Mr. Vanderbilt.
I have no further questions.
Mr. Wong, you may close. You have a little over 6 minutes left. You got to unmute yourself, Mr. Wong.
Thank you. I am unmuted. Can you hear me?
I can now.
Okay. I should have made an oral motion earlier to strike the decision in order for summary judgment in CV19-013. It's not part of the record of this case, and it shouldn't be considered by this court. The same way with respect to Mr. Vanderbilt's arguments. I refute them and disagree with many of them, but I ask the court to simply look at the briefs that were filed together with the records on appeal and the SERs and the ERs and the supplemental ERs to go ahead and decide this case rather than the argument of Mr. Vanderbilt, which I take issue with many times. There also exists a need for the Supreme Court to address my motion to set aside the set aside the non-judicial foreclosures that were conducted after the summary judgment was issued and the stay was lifted. Otherwise, like in Sonana, the court may not have jurisdiction to rule on whether or not it wants to set aside the summary judgment. That's still pending before this court. The old rule says there are equitable exceptions, or if a statute provides for the exception. I argue to the trial court that Rule 13B is tantamount to a statute providing for the exception to the old rule. We've come a long way since 1939. I ask the court to keep in touch with the new rule and allow this new rule to prevail in this particular case.
But I still have difficulty looking at the application of that rule when it's not raised as a counterclaim, but raised as an affirmative claim.
Yes, I understand that, Justice. I just cannot argue more than using substance over form. Really, it was an affirmative defense for a counterclaim, defense to Cyfred's efforts to non-judicially foreclose.
But you also recognize, Mr. Wong, that we are limited in how we can deviate from the principles of law and exercise our discretion in reference to applicable authority. If you cite no authority to support your claim, I think it's unfair to ask us to be fair in terms of how you look at it when we are confined in how we can apply the law.
I appreciate what your comments were, Chief Justice. Mr. Justice Torres asked for the citation in the record to the facts that support Cyfred's obligation to pay its attorney's fees, and that obligation being probably more than $200,000. I asked him to look at ER 209, excerpt of record 209, which is my declaration. Yes, I was stating what Mr. Gill told me in his deposition because I just completed the deposition. I had to file something in court to show the facts. But when you look at those facts and construe them in the light most favorable, you'll see that the $281,000 in debt, combined with the $96,000 Mr. Vanderbilt is claiming in this particular case, clearly exceeds the $168,000 in assets.
Is the deposition part of the excerpts of record? No, it's just based on your affidavit citing to the deposition.
Correct. My affidavit concerning what he stated in his deposition, which are admissible admissions. Okay. With respect to this case and the 4 others pending, it's all because Cyfred didn't want to record a quitclaim deed that Stephanie Mendiola gave it a year after the settlement closed. And all this litigation has transpired. All Mr. Gill had to do was sign the deed and record it with the Department of Land Management. And none of this would have happened. I do not choose to be litigating these cases for the rest of my life. I wanted to
Your Honors, I'm sorry, I have to raise an objection. This is not.
Mr. Vanderbilt, Mr. Vanderbilt,
Yes,
you
sir.
know, we're capable of discerning what's on the record and what's not on the record.
I
Okay.
put a lot of emphasis into the burden of showing. I haven't seen where this court has decided who has the burden of showing summary judgment qualities or requirements. I contend that it was the move on that has the burden to show either affirmative defenses or counterclaims don't have any merit. And Mr. Vanderbilt presented nothing with respect to solvency or insolvency in terms of his motion for summary judgment and reply, presented nothing in terms of whether or not this special ground for equitable relief that Cyfred could become insolvent easily and improperly in terms of opposition. And if you don't present any facts to indicate that there is no genuine issue of material fact, you shouldn't be able to prevail on summary judgment in this particular case.
Yeah, but as the trial court pointed out, you know, Mr. Vanderbilt pointed out that these allegations, assertions were unliquidated, contingent, lack mutuality, and even under the exception, equity exception that you're trying to argue should apply as the principles of law, you know, you had the burden, even if we construe the facts most favorable to the non-moving party, to come forward and assert that, that there are contrary facts. And what the trial court stated that is, you know, your assertions were just speculative, that there was no judgment that reduced the amounts of what is being, there was no judgment that reflected that. And it just were assertions on your part, which, you know, we're quite capable of determining whether those are facts or not facts.
Again, the burden of showing is different from the burden of proof. I acknowledge that my clients have the burden of proof to show set off at the time of trial, but the burden of showing on a motion for summary judgment has got to fall with the move on. He is the one that should be showing this particular court over the entire record, because the judge has sua sponte authority to change her interlocutory summary judgment decision over the entire record, that there are no genuine issues of fact as to these particular items, either set off as an affirmative defense or set off as a permissive counterclaim. And this wasn't done. And that's why summary judgment is improper in this particular case. Last point on mutuality. I'm sure Justice Torres is still concerned about that. My clients have agreed, and it's in the record somewhere, I don't know where, that they will go ahead and share their attorney's fees and costs with each other, because we came into this all for one and one for all. There are 7 of my clients out of the 14 who have same claims against Cyfred in 0735-18. They have mutuality in terms of the same parties and the same claims. There are others who don't have that certain mutuality, but they are entitled to collect that portion of the attorney's fees of the other people in CV0426-18. Again, looking at that Illinois Supreme Court decision that the Supreme Court of the United States cited to with approval, that to me shows pretty clearly that you don't need mutuality with respect to a claim that you may assert as a set-off. I thank the justices for listening to me, and I hope you can find your way to overturn the summary judgment. All other cases, all other decisions are based on that summary judgment. Reverse all of them. Reinstate the preliminary injunction to protect my clients from non-judicial foreclosures, and remand the case for further proceedings with the trial court. Thank you very much.
Thank you, Mr. Wong. The court will take the matter in advisement. We thank counsel for their arguments, and the court will now stand adjourned. Thank you, counsels.
Thank you, counsel.
Thank you, Your Honor.